whys, how, by whom, when, about what exactly. There are so many of those. If you are able to apply that thought of process or that kind of reasoning, why did you not apply it here? It's on that basis that I say this says nothing at all. So by parity of reasoning, in accordance with your own reasoning, when you concluded that what you were being asked was vague, why did you not see this as vague as well? It says nothing, I suggest to you. Do you agree or not?
It may say nothing in there, it refers to the dockets.
So you are happy that it says nothing.
It doesn't make out any allegations.
Exactly,
yes.
Exactly. Now, go to section 32 of the NPA Act. And please tell me when you are there. 32.
I am there, Chair.
Do you see that in subsection 1, that is section 32(1), there it's stated how you are to carry out your functions, and that is amongst others without fear, favor, or prejudice. And what I want to emphasize here is without fear. And then in subsection 2, that is section 32(2), the oath of prosecutors is actually set out there. You do see it, eh?
I see that, Chair.
It also captures the same words, without fear, that is, you will exercise your functions as a prosecutor, and you happen to be a senior one at that. So you will exercise your functions as a prosecutor without fear, favor, or prejudice. Again, I emphasize without fear. Now, if you accept, as you have just done, that there was nothing whatsoever in the minister's letter, what stopped you from writing back to the ministry and saying, we do not have a section 27 referral. Therefore, we cannot do anything about this. And you did not even have to go to the content of the letter. But because there was nothing in the content of the letter that should also have given you comfort as a prosecutor, that I do not have to follow up on anything here, because there's nothing. You have accepted that there was nothing. Why did you not write back to the minister and say, in the absence of a section 27 referral, we as IDEC cannot do anything? So that it would then have been the ministry that saw to it that a section 27 referral was placed before IDEC. Why did you not write such a letter? Were you fearful of the minister?
Not at all. And that is
why then did you not write such a letter?
That is why I said, Chair.
Sorry, you spoke over me. Why then did you not write such a letter?
That is why I said, Chair, we'd have to look for the letter that the response. What did I write in my response to the minister?
But surely, sorry. But surely, that letter could not possibly have said, Minister, we are not going to do anything about this because there's no section 27 referral, because that would have been at variance with or at odds with you instructing Mr. Perumal to follow up with Mr. Adams. So that letter, even if we were to look at it, it's not likely to have said what I'm suggesting you ought to have done. So do you think that letter is going to assist you?
I'd have to look at the contents.
Do you think it's going to assist you as you sit there, seriously? Do you think it's going to assist you?
Not at all.
It cannot possibly do so. It cannot possibly do so, because such contents would have been, as I say, at odds with the instruction you gave to Mr. Perumal. You agree?
I agree, Chair.
Thank you. Yes, ma'am.
Can I just follow up on that? And I want to make a proposition to you that when you look at the letter from Mr. Nkabinde, as you agree, it says nothing. It says, I attach a copy of written correspondence from Mr. Adams to the minister, not to you. And then it gives a list of cases. It says allegations contained therein implicate very senior members of the SAPS and are viewed in a serious light. And case dockets were registered, and he gives you those case dockets. And then he says, due to the nature of the allegations made by Fadil Adams, Honorable Fadil Adams, which is deemed to be quite sensitive and which contains allegations of criminal misconduct, this office requests the investigating director to consider investigating the same. And then the last is, you will advise him what you're doing. You'll advise Mr. Adams. Now, for you, the proposition that I want to make to you is for you to instruct Chief Perumal to speak to Mr. Adams. You must have had sight of these emails for you to form a view that there is possibly a matter that falls within our Section 27. You must have looked at MK 15 to 82. Otherwise, your decision doesn't make sense. That just on MK 16, you say to Mr. Perumal, speak to Mr. Adams. When 16 says nothing, as the chair says, it doesn't allege what crime it speaks about. Allegations are sensitive, doesn't tell you anything. So you don't know whether they're talking about theft of a notebook on MK 16. Could have been anything. So it cannot be. And I would be surprised if you acted on MK 16 to say to Mr. Perumal, speak to Mr. Adams, so that we can get an affidavit from him. That conduct of yours to say to Mr. Perumal, to Chief Perumal, speak to Mr. Adams, makes sense only if you've seen these emails and you've seen that there are allegations of interception of dockets. As you were starting to say that the email seems to speak to corruption of sorts, you have to have seen this. That's my proposition to you, that you must have seen these emails by the time or before you spoke to Perumal, and that's what informed you saying to Mr. Perumal, speak to Mr. Adams. What do you say to that?
I can't disagree with you, Commissioner Baloyi.
Thank you.
Sorry, let me just follow up on a response you gave when I engaged you. So in the end, you accepted that you could not possibly have written a letter to the minister saying there's nothing we can do in the absence of a Section 27 referral. So you accepted your letter could not possibly have said that. I asked you, did you act in the manner in which you did because you were fearful of the minister? And I thought your response was in the negative, correct?
Correct.
If you were not fearful of the minister, why then did you act? What motivated you to act in circumstances where there was nothing in the content of the letter from the minister? You were not fearful of the minister, as you suggest, but you still went ahead regardless and gave the instruction that you gave to Mr. Perumal. What motivated you? What was the motive behind your action? If it was not fear of the minister, what then was the motive for you to act in the manner in which you did?
Is to follow up on, is there a Section 27?
Is that all you asked Mr. Perumal to do?
That is all, because there's a reference to a Section 27. There is no Section 27. Mr. Perumal to contact Mr. Adams to find out if there's a 27 or to get a 27.
Did you say this before, or are you saying it for the first time? If you did say it, I may have not heard you. What I'm referring to as to whether you are mentioning it for the first time now is whether your instruction to Mr. Perumal was for him to find out if there was a Section 27 referral. Did you say that before?
No, Chair, I didn't say that before.
You are saying it for the first time now. I would have expected you to say that much, much earlier, but I will leave it at that.
I'm reading again.
Sorry?
Sorry, I was reading again and going through what it asked.
Okay, thank you, thank you.
Thank you, Chair.
Advocate
If I,
Johnson, sorry, one last one. Do you see that as far as the minister is concerned, his letter was the Section 27 referral? Because if you look at the heading, they say referral and request for investigation in terms of Section 27. So as far as the minister was concerned, this is the Section 27. So the appropriate answer from you would have been, this does not comply with Section 27. That's the end of the story.
In fact, to add to that, nothing in this letter leads you to Mr. Adams. As Commissioner Kumalo says, it is the ministry that is referring and purporting to refer in terms of Section 27. And if you were going to ask for a Section 27 affidavit, it is from Mr. Nkabinde that you ask for, because he's the one that's purporting to refer. It doesn't direct you to Mr. Adams. The complaint has been laid with them, and Nkabinde says, I'm lodging a Section 27 complaint. And you have no business, at least on the basis of this letter, to go to Mr. Adams for a Section 27 affidavit. You go to Mr. Nkabinde for a Section 27 affidavit. You say to him, this is not a proper referral. If you want us to investigate in terms of Section 27, as Commissioner Kumalo says, give us an affidavit.
I read it differently, Commissioner Balo.
How do you read it differently?
It says referral and request for investigation in terms of Section 27. And he does make reference to the Honorable Fadil Adams. We don't have anything from Fadil Adams. And so the request to Perumal to get a Section 27 from Fadil Adams is based on the referral and request for investigation in terms of Section 27.
Mr. Nkabinde is asking you to investigate. Mr. Adams is not asking you to investigate. He has not communicated with you. He hasn't. Even on the version which you, on the proposition that I made to you, that you must have seen the emails that he sent to the minister, even on that, he's not directing anything to you. It is Mr. Nkabinde. He raises his complaint with the minister. That's what he does.
Yes.
The minister's chief of staff lodges with you a complaint, and he calls it a Section 27 complaint. The only reference he makes to Mr. Adams is to say, we've received, the minister has received a complaint from Mr. Adams. Please investigate. And I refer this to you in terms of Section 27. So the person that must give you the affidavit is Mr. Nkabinde, and it's not apparent why you thought that this is a complaint to IDEC from Mr. Adams, because it's not a complaint from Mr. Adams to IDEC. At this point, it's not.
I see where you're going to, Commissioner Balo.
It's like this,
But
Advocate.
sorry. Do you agree? Do you agree?
I agree with her interpretation. Yes.
Thank you.
It's like this. So Mr. Adams writes to the minister's office. He's unhappy about the 4 dockets, and he asks the minister's office to intervene. So the minister's office has at least 3 choices. One is the inspectorate, the other one is IPID, and the other one is IDEC. So they have those 3. So far you are with me. You agree?
I agree.
Based on the nature of the allegations, as vague as they are, they have those 3 options. The minister's office then picks one, and they say, we pick IDEC. And we will do a referral to IDEC in terms of Section 27. of the NPA Act. It's not Mr. Adams who says, I choose IDEC. It is the Minister's Office, based on what we see in this letter. Do you agree so far?
I agree so
Yes.
far.
And they say, as far as the Minister's Office is concerned, the allegations in the correspondence by Mr. Adams, they regard them as quite sensitive. That's the Minister's Office. And they contain allegations of criminal misconduct. That's the Minister's Office. They then say, this office, that is the Minister's Office, this office requests Advocate Johnson to consider investigating the matter. That's the last paragraph on 310. So do you see that it refers to this office being the Minister's Office? Do you see that?
I say that.
And it is the Minister's Office that is asking IDEC to investigate.
Correct.
Yes. So the request is by the Minister's Office. And they say Adams was advised to await Advocate Johnson's decision. A decision on the request by the Minister's Office.
Yes.
Do you accept that? Yes.
Thank you, Commissioners. If I could just add, and what the Minister's Office requested IDEC to investigate is the alleged interception of the dockets. That's it. Not the allegations set out in the respective dockets. That was never the request to you. Do you accept that?
I accept that.
So if you understood the request to be an investigation into the alleged interception and interference of dockets opened by Mr. Adams, that surely should have been the confines of your investigation. Whether or not dockets were opened and intercepted, whether there has been interference with the dockets, regardless of the content of the dockets. Because otherwise you would have been investigating what you were not requested to investigate. Would you accept that your investigation would have been that narrow, would be looking into the interception only?
In terms of this letter, yes.
Yes. So we then, if we look at the emails at 283 and 284, that is consistent with what Mr. Adams complains about in his emails to the minister. It is the interception. After tea, perhaps you will shed light on having solicited the Section 27 affidavit as IDEC did. How do we end up with claims of Kumalo Lushaba Madondo siphoning money from the secret account fund with cover-ups of General Lushaba's incident with the appointment of a lady working at BMW in a sensitive post? How does that fit into the request, specific request made to you of interception? Why is Mr. Adams's affidavit not confined specifically to the complaint he had laid with the minister? Was that at the instigation by IDEC? It can only be at the instigation of IDEC. So there's Mr. Adams' complaint of interference, and then there seemingly is a parallel investigation attached to that complaint initiated by IDEC. Is that where we are at?
I'm going to come back to you after tea because I'd have to speak to Mr. Perumal about what he spoke to Mr. Adams about and how we arrived at this.
No. You will come back.
At that point, perhaps let's take the adjournment
Okay.
and come back at 11:35.
Thank you,
Let's
Chair.
adjourn.
It's 11:34. We are ready to resume. Please make sure that your devices are quiet. Thank you.
Yes, Ms. Sillo.
Thank you, Chair. Advocate Johnson, when we broke for tea, we had established that the minister's office complaint was based in turn on Mr. Adams's complaint of interception of his dockets. We agree that.
Correct?
Okay. We know that upon receipt of that communication from the minister's office, with or without annexures, you then instructed Mr. Perumal to obtain a Section 27 affidavit from Mr. Adams. My question was, if the complaint was interception of the dockets, not the content of the dockets, by you I mean IDEC, must have instructed Mr. Adams to include in his Section 27 matters that do not constitute interception. And you indicated that you needed to talk to Mr. Perumal. I take it you've had a chance to and are able to shed light on how we end up with a Section 27 affidavit reading as it does, inconsistent with the complaint laid before IDEC by the minister's office.
Commissioners, I did call Mr. Perumal during the tea break, and I give feedback as follows. The referral and request for investigation in terms of Section 27 in the letter by the Minister referred to Honorable Fadil Adams and referred to dockets. The ID asked Mr. Perumal to contact Mr. Adams to find out if he had a 27, which he did. He called Mr. Adams to indicate that IDEC cannot assist you in the absence of a Section 27 referral. Mr. Adams said, I have dockets opened already that make out allegations. Mr. Perumal advised him that we cannot just take those dockets in the absence of a Section 27. He told him to see a legal person and look at Section 27, and if he was of a mind to then refer a matter in terms of Section 27. Accordingly, there is a 27 dated the 21st of November, signed in the Western Cape, that was compiled by Mr. Adams without IDEC, which he sent and which has the detail it has.
The complaint, the only complainant as at the 11th of November was the Office of the Minister. And that complaint concerned interception of dockets. So the complaint itself does not concern itself with the contents of the dockets. It's only the act of interception. Do you agree with me? That is what was communicated to you by the Minister's office on the 11th of November in terms of Annexure MK16.
I beg to differ, if I could explain.
Yes, please.
The Minister is not just referring to the dockets. The Minister says, the allegations contained therein implicate very senior members of the South African Police Service and viewed in a serious light, and case dockets were registered as per the following cases, meaning whatever allegations that implicate senior members of SAPS are in these 4 dockets referred on 310. He goes further to say, due to the nature of the allegations made by Honorable Fadil Adams, which is deemed to be quite sensitive and which contains allegations of criminal misconduct, this office requests the investigating director to consider the same.
Okay, now let's look at the paragraph you just read, the allegations contained therein. What the reference to the therein, and I propose to you that therein is the correspondence addressed to the minister. So the allegations contained in the correspondence from Mr. Adams to the minister implicate very senior members of the South African police. And the implication is that they intercepted the dockets.
I don't read it like that.
How do you read it?
I read that the allegations contained therein, in these dockets, in the dockets, implicate very senior members of the South African Police Services.
What in this communication gives you a sense that the minister or Mr. Nkabinde has seen the contents of the dockets?
I'm not saying they saw the contents of the dockets. They refer to Mr. Adams and they say the allegations contained by Mr. Adams implicate very senior members of the South African Police Service and are viewed in a serious light, and case dockets were registered as per the following case numbers.
But if your reading of this letter is correct, then the minister's office must have seen the dockets. Otherwise, they're not in a position to express a view that the allegations are viewed in a serious light and that they are quite sensitive, what is contained therein, if it is a reference to the dockets. The minister must have seen these dockets for your reading to be correct. It must be so.
For the way I read them, Commissioner Baloy, he refers to Adams. Adams would have made the allegations. I'm not sure in what form he made them to the minister.
No. What we know from this letter is the minister has been given correspondence by Adams. That's what that letter says. There's correspondence from Mr. Adams. You say the second paragraph and the third paragraph do not refer to that correspondence unless you're suggesting the minister must have had a telephone call with Mr. Adams, and that's why he's able to talk about these dockets, the content of these dockets. And I suspect that's not what you want to say. Because the next question would be, how do you know they had a conversation about the dockets and what's contained in the dockets? So let's read the letter sensibly. Paragraph 1 says, I attach a copy of the correspondence received from Mr. Adams. That's what it says.
Yes.
And then paragraph 2 says, the allegations contained therein implicate serious members of the South African police. I want to say to you that a sensible reading of this first paragraph and the second paragraph is the contained therein refers or must refer to the attached correspondence. That is a sensible reading. Otherwise, why does he mention that letter to you?
That is correct.
Yes. So your reading of it to say, well, when he talks about implicating senior officers and containing sensitive matter, he's referring to what is contained in the dockets. It doesn't work. It's not a sensible way of reading this letter. But more importantly and seriously, it works only if you say that the minister must have had a conversation with Mr. Adams about these dockets to know that matter contained therein in those dockets is sensitive and it implicates senior police officers. And who are those senior police officers? You agree with me? You must agree with me.
I agree with the reading of a copy of a written correspondence which would have set out those serious allegations as contained.
Yes.
And therefore the reference to the dockets, because he refers to the dockets.
Yes.
But that the written correspondence would have set out these serious allegations.
Yes, that's the only way it works. Thank you.
And for that, you would have to go to page 283 of the same bundle. 283.
That is the correspondence we suggested was attached to the minister's
The serious
letter.
allegations implicating senior officers are contained there because
Apologies, Commissioner. MK 15, Please go to MK 15
I am there.
and then to page 283.
I am there.
Thank you.
So that email of 1 November 2024 at 8:21, that is the correspondence addressed to the minister. And the docket numbers are there. And then allegation 2 is that I was told the dockets were intercepted. And then he says, I traveled to Johannesburg, Orlando, opened new dockets you see there. Then he implicates senior officers because he then says they interfered in the investigative process. And he was notified that Gauteng is following the same process. And the request to the minister is, I urgently and humbly ask the minister to intervene to ensure the integrity of the investigative process is maintained. So this is the request that gives rise to the referral to IDEC. And that was Advocate Sillo's point, that the referral to IDEC was about these allegations implicating senior officers, not for IDEC to go take over the dockets that were opened in Orlando and the Western Cape and investigate those underlying allegations in those dockets. So having seen this, you can now go back to the letter and then respond. Sorry, having seen this, you can now go back to the letter. It's on 310 and respond to Advocate Sillo's question.
I still maintain that although you have that email, this letter tells you referral and request for investigation in terms of Section 27. It does talk to copy of written correspondence to the minister by Fadil Adams, and therein are serious allegations. And due to the nature of these allegations, they are referring then to the allegations as he makes out in his written correspondence, which must almost invariably, it would seem, refer to the dockets. That is my reading, Commissioner. I'm not saying that it cannot be read differently. I'm saying that is my reading. And I can't take it further than that is my reading of the title, what is referred to, and what subsequently happened.
And you insist on that reading, notwithstanding the fact that it belies any logical form of interpretation, but you insist on that wording, on that interpretation.
I believe that the interpretation is logical.
Okay. Now, under which case number or inquiry number did IDEC investigate the claim of interception? That's the original claim by Mr. Adams. That is the complaint that the minister purported to refer to IDEC.
So in the communications with Mr. Adams, he was asked for his Section 27.
I'm asking under which case number or inquiry number?
It
there.
would all have been under the one inquiry under which the Section 27 came. There wasn't a separate inquiry for an interception or a separate inquiry for something else. When the 27 came in, if I may, Counsel, when the 27 came in, it was given a reference number.
Yes.
And all those matters that flow from whatever the allegations are, including in the 27, where he says in one of the paragraphs that the dockets were intercepted or the dockets were taken for reasons that are not explained. They form part of his complaint.
Yes.
All one complaint.
Yes. I'm interested in the investigation into the interception because I did not see it in the docket, what we call the Mokwele matter. I didn't see that particular investigation in the docket, and I wanted to find out whether IDEC ever pursued that complaint, that specific complaint of interception of Mr. Adams's dockets. or whether it concentrated more on that part of the Section 27 referral that, as I suggest, was initiated by IDEC.
When the referral had come in, we had to find out where these dockets are. That was part of that exercise. In order to locate the dockets, to determine whether these dockets had in fact been intercepted and were no longer where they were. To that end, Council, what we did is we wrote, because his last reference is, I opened dockets in Gauteng. A letter was written to the Provincial Commissioner Detectives, Major General Kumalo, requesting the dockets.
I'm sorry to interject. Do you possibly have a date for that letter immediately at hand?
Will you please give me a moment? It should have been in that would have been the 6th of December.
Okay.
I speak under correction, but in all likelihood, it is the 6th. Sorry, I made a small note, 6th of December.
And did you receive a response while we are on that point? Did you receive a response, and if so, when?
General Kumalo, and sorry, this is a different
Yes.
Kumalo, not General Dumisani Kumalo. The PC for detectives indicated that he knew about these dockets, but that these dockets were not with him. He was going to tell us where to find those dockets. In the interim, he then indicated that the dockets could be with the DPCI. When we contacted the DPCI, these dockets were not with them. And in that process, one of the investigators found out that the dockets actually were with the SAPS inspectorate, more so the head of the inspectorate, General Peter Jacobs.
And when was this discovery?
All on the 6th.
All on the 6th?
All on the 6th, because we're looking for the dockets. He's saying the dockets are missing.
Do you know how he discovered that, by any chance?
I know that the investigator indicated that he received information. I don't have the detail of the information, but he received information that the docket is with the head of the inspectorate, Lieutenant General Peter Jacobs.
Going back to your team, we had quite a number of investigators there that you identified. Which particular investigator
It would
is
have
this?
been Mr. Rapeso.
Okay. We got a bit sidetracked. Remember, going back to the letter from the ministry regarding interception, I wanted to find out that the case of interception of the specific dockets listed there, where did that investigation end?
The dockets were found on that day.
But should that not have been the end of your inquiry then?
No.
I mean, his complaint, remember his complaint is that dockets have been intercepted. That's what his emails are about.
Yes.
He's not making the allegations that you later find in the Section 27 that you have accepted, you solicited. So we're still at the earlier stages where you get a complaint that dockets have been intercepted. You are telling us that you then inquired and in fact found that they are accounted for
Yes.
in the subsystem.
Yes.
You get told that. Isn't that the end of his complaint? And shouldn't that have been the end of the complaint?
Commissioner Kumalo, that was one part of
I'm still Commissioner Baloyi.
Sorry. He looks and smiles there the entire time. And so one invariably, I do apologize, looks at him. Please don't frown, sir.
I have to change because clearly that's a problem.
It is the one thing that gives comfort when you sit here as a witness is a smiling face. And we digress, and I apologize. It couldn't stop there, because we now need to see what's in these dockets, because here's an allegation that Adams is saying, there are serious allegations I am making. They are contained in these dockets, but beyond the dockets, I have an issue because these dockets are missing. He does say so in the 27. So once we determine, counsel, that the dockets are with the inspectorate, we cannot ask the inspectorate for the dockets. And I'll tell you why I say that. It's out of just normal practice.
No, just hold on your explanation.
Sorry, Commissioner Baloyi.
My question is pre the 27. We are still, the 27th is in November. Okay, now carry on. I do apologize.
Sorry, we get the section 27 on the 21st of November. That allows us to be able to look for what the allegations allude to. In order for us to have access to the dockets, police will not give IDEC dockets if IDEC does not have an investigation. On the 6th of December, we, having had the Section 27 since the 21st of November, the prosecutor, Advocate Ramsamy, is able to submit a Section 2813 application, which initiates an investigation. It is on that basis, Commissioners, that we are able to write now to the head of detectives, because ordinarily the custodians of the dockets, especially under investigation, are the detectives. We write to the head of detectives indicating that IDEC has initiated an investigation, and the investigation requires that we have access to these dockets.
Perhaps this might be the appropriate point
Sorry.
to turn to the referral affidavit itself. But I do so momentarily for purposes of the complaint of interception. That would be at your file 2, page 512. That will run till 516. If we just run ahead to page 516, you confirm that is it's signed above the name F. Adams. Okay, Adams is misspelled, but I take it to be F. Adams MP, dated the 21st of November 24 in Cape Town, and commissioned by Commissioner of Oaths, as indicated. You confirm that?
I confirm I
Now,
see that.
the conversation we're having, if we go back to paragraph 1, paragraph 1 reads as follows. In my capacity as a member of Parliament for the Republic of South Africa, I first opened 3 cases in Cape Town Police Station with case numbers Cape Town, and they are stated. After I opened these cases, I take it I was informed that the cases were taken from the Cape Town Police Station to the Office of the Provincial Commissioner, Western Cape. I do not trust the Provincial Commissioner General particularly, and believe that a deliberate attempt is taking place to get rid of the cases I had reported and to protect those against whom I made the cases. End of quote. That is the investigation I'm asking about. Did you ever investigate the claims against General particular? That is the interception. And I still don't understand whether or not you investigated that, you being IDEC, or you didn't. And if you investigated, where you ever landed.
In all honesty, Counsel, I cannot tell you that there was a separate investigation about that interception.
Yes.
I know that we sought to find those dockets, and we then, in fact, found those dockets.
Your finding of the dockets surely doesn't address the complaint of interception?
No, it doesn't.
Yes.
And what I'm saying is there must be an investigation. I can come back to you with a reference to an investigation. But I know that at the time, the purpose was to first find these dockets, which we in fact did, and to then determine what the allegations are in those dockets. Do they talk to the 27, and what is the way forward?
Okay, so would there be an investigation in your office that you don't know about? Because your answer suggests that your people may well be conducting investigations that you're not aware of.
Not that I won't know of an investigation, but when you have matters of this nature, Commissioner Baloy, they divide the matters up into different legs of investigation so that they can deal with them differently. I may not be aware of a specific leg of investigation, but I am aware that there is an investigation or investigations arising out of the Section 27.
So you would expect.
I would expect.
And we should expect that when you come back to us after lunch, you will tell us there is an investigation into this interception. This is the team that is dealing with that, and it is being done under case number so-and-so. It's information that you should be able to get. Thank you.
Thank you, Commissioner Baloy. So then just to recap where we are at, we know that we started with email communication by Mr. Adams to the Office of the Minister. The Minister then directed the letter, dated the Minister's office, directed the letter dated the 11th of November 2024 to yourself. And we know that subsequent to that, you directed Mr. Perumal to obtain an affidavit from Mr. Adams. We are in agreement there. Okay, where did I lose you?
Sorry. Correction on the last part. Or let's leave it at that. I think it's semantics. It's okay. I'm not going to fight about the semantics. Sorry, Chair.
Then having done so, and the issue at the time was interception of the dockets. A claim by Mr. Adams. It was the interception of the dockets. What we don't have before us is a file on the investigation regarding that particular complaint. What we then have instead is what we have come to call the Mukwele matter, which then is born of claims advanced by Mr. Adams at the instance of IDEC, as reflected in the Section 27 affidavit. Do you agree with me thus far?
Yes, and that we miss a matter before the Mukwele matter, which was the Lushaba matter. That was the first matter that was dealt with, and then it was the Mukwele matter.
Okay.
I just didn't want us to miss that.
I'm not sure I understand, because in this complaint we are going to come across the Lushaba matter.
Yes, and
now, is that a separate investigation?
that was dealt with. So what the prosecutors did.
Let me just say something to I guess, clear the cobwebs in my head. I want to determine how many separate investigations there are. My first was that the first investigation would at least have involved an investigation into the conduct of General Petekile as set out in paragraph 1. That you say you'll check on the file regarding that investigation. The second is the Mukwele matter, quote, quote unquote. It's unfortunate we have to use her name in that manner, but it's the quickest way of making reference without confusing each other. Now, you're suggesting that there is a third investigation on the Lushaba matter.
When the prosecutors got the Section 27 referral counsel, they broke it up as follows. Started with the General Lushaba matter.
Yes.
That's the first matter. The Mukwele matter being...
Apologies, just a second, thanks. Thanks, you may continue.
Thank you, Commissioners. So when the matters were broken up, and I think they were broken up, as the prosecutor explained, in terms of the different categories of offenses If you took them all as one, we would have had a lot of issues, from misjoinder to 10 people standing in the dock, one facing one count of something and someone facing 10 of the other, and it would have been a mismatch. So they took it in terms of the allegations and grouped them accordingly. In terms of what happened in the sequence would have been, as they identified, the housebreaking incident of General Lushaba. That was the first investigation. That was the first matter, counsel, that was enrolled. Thereafter, it was the Mokwele matter. There is then a third investigation. That is the one for which the warrants were held over, just for context, in terms of Lieutenant General Khumalo and General Madondo. And then there are other matters that also emanate from this complaint.
How many other matters?
There are, I know for 4, 5, there would be 6.
6 other matters.
6 other matters.
And they all, you say they all emanate from the Section 27.
That is correct.
Are you able, over the course of the lunch break, I guess, to prepare a list for us of those matters and to indicate whether they are filed, they have different case numbers or inquiry numbers or any other useful reference?
I do know that with the Lushaba matter, it's a separate case.
Yes.
Of course, as is with the Mokwele matter.
Yes.
And that had the other matter been enrolled, it would have also had its own case.
Yes.
Okay.
And that's why I say it might possibly be a case number or an inquiry number, just so we know which we are pursuing. Now that we have started with the Section 27 referral, let's for a moment go back to Section 27 of the NPA Act.
Before you do that, can I just check that the attorneys have given you a copy? Because I saw that you were struggling. Can they just make sure that they give you the copy of the Act?
Oh, apologies. I'd assume the witness perhaps was...
I do. I'll keep this one here. I
Yes.
think
Yeah,
I do
she's
have
got her
one.
own version,
And,
yes.
out of habit,
I noticed that when Chair was engaging you, you were struggling finding.
I think it's because I had too many documents on my table, Commissioner Khumalo.
So we took the extra effort to ask the attorneys to make a copy and put it in a file.
Thank you very much.
Thank you,
And then
Commissioner.
I'm going to be respectful and use the file that was made available. Thank you.
I think so, Advocate Johnson, after all that effort, right?
Yes.
So-
And the few trees that we might have,
Absolutely.
yes.
Absolutely. We are now at Section 27. And Section 27 tells us the affidavit, what the affidavit contemplated therein must contain. Correct? I'm sure it's a section you are well familiar with. You've had a number of
Yes, I
referrals.
just went to the wrong side, sorry. I am there. Thank you.
Section 27. So you do agree, sections 27 sub A, sub B, and to some extent sub C, if there should be other relevant information, dictates what the affidavit should contain, Section 27 affidavit.
Correct?
What are the consequences where an affidavit lacking in complete compliance with Section 27, what would be the consequences insofar as IDEX trigger is concerned?
Where an Section 27 affidavit is insufficient for any one of a number of reasons. We ordinarily would ask the complainant to supplement or amplify and indicate what the shortcomings are, which parts are short. If the complainant is unable to amplify any one portion or portions that would then fulfill the requirements of Section 27, we then have to indicate that we are unable to take the matter because the matter must fulfill certain requirements.
Okay. Thank you. Let's turn then to the Section 27 affidavit that we received.
Do you do this, that is the request for a supplement? Do you do that in all instances where an affidavit is lacking in the necessary detail?
Chair, especially where just from a glance, it would seem that they're just missing something and there's a likelihood it falls within the mandate. You ask them, and when they amplify and you say, okay, it still falls short.
Okay,
then
so
we don't.
that's exactly what I wanted to find out. So reading it, you are of the view that it does fall within your mandate, but you just want a supplement on certain specific issues or on a specific issue. But at least it's already there within the realm, as it were.
Correct, Chair.
Meaning, if it's woefully hopeless, you just reject that, correct?
That is correct.
All right, thank you.
Just follow up on that by way of an example or question. So we're looking at 27 and the requirements thereof. If you are given an affidavit that says, I suspect that money is being stolen, that's A. So they've told you the nature of the suspicion. And then they don't tell you the grounds on which the suspicion is based. And whatever else they say in C does not tell you the grounds on which the suspicion is based. There's been a non-compliance with B, right? What do you do?
You would then check if they have a source of information. That
So
is,
you would
what
still
do you
ask
base
them-
it on?
Sorry. So you would, even if they haven't set out grounds in their affidavit, they simply say, I suspect money is being stolen. You're saying you then ask them for a supplementary affidavit?
No, if it's just, I suspect, and there's nothing more to it, then it does not fulfill.
And so,
Because sorry, Commissioner.
yeah, no, Kira,
You have to be mindful of the prodding.
yes.
And trying to elicit something they know they should tell you. Because what does happen is, ordinarily, without saying what you want, we are able to engage a Section 27 referral and indicate these are the requirements. Your affidavit does not make out these requirements. And there and then, in almost most cases, people are able to say, well, I gave you what I have. And that just finishes that part of it.
Thank you.
And when people tell you, I gave you what I have, and there are clearly no grounds in that affidavit, what does IDEC do?
It may be, Council, that it is insufficient for the purposes of IDEC. Where it has been insufficient for the purposes of IDEC, but we are aware that it could go to the detectives and or it could go to the DPCI, we write to the referral or to the referee, I apologize, to indicate whilst this does not comply with IDEC's mandate, you are able to refer this matter to the detectives. We are writing to, so we do two things. We inform the complainant where they can go to, and then we also write to the agency that we are able to send it to, together with a copy of whatever information might have been received. We have also been able to do that where, for example, it is something that is civil in nature, but falls within the mandate of the SIU. And we would say to them, you might be able to find recourse here with the SIU. So we don't just leave them in the lurch if, in fact, it does make out allegations that are investigated by a different agency. We write to them, we write to the agency, and we send that material as well.
So at least where we land, and I'm testing my understanding of Section 27, there are two main requirements in that section. The affidavit must spell out the suspicion that the referee holds, and then to advance grounds to support every specific suspicion. IDEC has got the power to request maybe substantiation, clarification from the referee, where there are shortcomings with compliance with Section 27. In the event that the suspicions are not substantiated and grounds not advanced by way of example, then IDEC cannot investigate the matter. It would normally refer it to another appropriate law enforcement agency.
Correct,
Is that a
Councillor.
fair summary? Let's look then at the Section 27 referral received from Mr. Adams. We will work through it in detail, but my summary of it I would like to share with you. What that affidavit, and that's file 2, page 512.
I do have it.
Thank you. That affidavit states the following. It highlights or shares with the reader 3 key suspicions that Mr. Adams harbors. The first is at paragraph 2. And therein, paragraph 2, it says, it expresses his growing concern that the head of crime intelligence, General Kumalo, General Lushaba, General Madondo, and other senior crime intelligence officers are busy with systematic capture of crime intelligence division. That's his first suspicion.
Council, may I ask a question? Am I allowed
Yes,
to
ma'am,
make
of
marks?
course.
Am I allowed to write
Yes,
on this document?
yes.
Okay, thank you.
If it's in the witness file, we will just replace it with a fresh copy.
You
So-
say, sorry, Council, you say that is the first allegation.
Yeah,
as
first
you ex-
suspicion. Remember that the affidavit actually requires the deponent to state what suspicions that they harbor. The first is there in paragraph 2. On my reading, the second would be at paragraph 4.
Let's take it step by step. Do you agree that that's the first suspicion?
That is the first one.
All right, thank you.
Thank you, Chair. And paragraph 3, for purposes then of completeness, the deponent speaks to what became clearer to him, how his suspicion became clearer to him, but he adds nothing more. He references an envelope, he says, was slipped under the door of his office in Parliament containing some crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. So he tells you that I have that, but he doesn't share the contents
Yes.
of those. Yes. The second suspicion is reflected in paragraph 4. And on my reading, that speaks to 2 suspicions. The first being a manipulation of procurement processes and processes to appoint and promote certain persons within crime intelligence. That's at paragraph 4, the first part of paragraph 4. The second part is, calls for the need to investigate appointments at various Secret Service offices. Sorry. Do you agree with me? That's
I
all.
have that.
At paragraph 5, he expresses a suspicion that some funds are being taken unlawfully from the secret funds account and given to Police Minister Becky Cele. At paragraph 6,
Before you do paragraph 6,
yes,
Yes,
Commissioner.
paragraph 5,
Yes.
did you consider it to contain 2 complaints? I mean, there's the first about money being suspected to be given to former Minister Cele, and then it seems to me there's a second leg to it, an allegation that the former minister appointed General Kumalo without an interview process and without Kumalo having worked as a, did you consider that another suspicion and complaint? Or did you not? And I must say before you answer that considering how the Mukwele matter has gone,
Yes,
I expect that
that would have been one of, it's a separate appointment issue.
if you haven't, there has to be an explanation
Yes.
why this was not
No,
investigated.
it is part of other appointments.
Okay, so you will come back to us with the
We will
detail
come
of
back,
it. Thank you.
To you. And may I just pause just to indicate, Commissioners, at the bottom of paragraph 4, it is not separate, but there is reference in the last line, which we had to look at as we go through all of the matters, likely points to launder money. So the money laundering is an aspect to consider when you look at money flows that may run through the course of all of these, and they are not, it's not a standalone matter.
Noted.
Sorry, you say that one, and you are referring to the last sentence of 4.
Correct, Chair.
And you say it goes with what?
It would go with 2, which is the manipulating of procurement processes, and then with 5, which Council had pointed out about the taken unlawfully from the secret funds.
Which sentence are you referring to in 2? Sentence or sentences?
Sorry, paragraph 4,
Para 4,
line 2.
line 2. Oh,
Yes, Chair, about the manipulating procurement processes.
okay. All right.
Just to indicate that money laundering is considered, but not as a standalone, just within the ambit of those matters.
Yes.
Okay.
Thank you, Chair.
So,
When I interrupted, Council, I think we were...
no, it's okay.
Fine.
Just on the point you've made, it's a suspicion, but couched more in request terms, because he's requesting that you look into these matters, I guess, because these secret service offices in the country are likely points to money laundering out of crime intelligence. So in that, I can accept that there is a suspicion that there is money laundering, except that he would like IDEC to investigate whether that laundering happens through various secret service offices.
Correct.
Okay. Then we agreed that at 5, it's a suspicion about secret funds being given to the former Minister Bekitele.
Yes, ma'am.
6, I don't see a suspicion in 6, so I would skip it for now. We'll come back to 6. The last suspicion that he then highlights is at 7, at page 515. My suspicion is that General Kumalo Lushaba Madondo and many of those who they've appointed are actively siphoning money from the secret fund accounts in the country. I understand that there are about 10 secret fund points in the country where monies can be drawn from, and all of these extraction points need to be investigated. That's another suspicion at 7.
May I take you back to 6, Council?
Yes, ma'am.
That is the Lushaba matter. And therein he has been charged not just with the housebreaking, but with the defeating and obstructing with regards to the loss of the equipment of crime intelligence and the non-disclosure thereof, and the fact that the secret information contained therein. So what I'm saying is the 6 is the Lushaba matter that is currently in court.
Yes, I'd ask that we skip that because we are trying,
Only
to distill from
from
the affidavit what the deponent suspects and what
Okay.
suspicions he has put forward to IDEC. So we have dealt with the suspicion at 7. Then 8 and 9 basically reverts to the dockets he had opened, the 3 cases in Cape Town, and the other 3 in Orlando Police Station. And it ends at 516. So if we at least roughly summarized his suspicions, I can see how he has complied with Section 27A, which is to set out the suspicions of a crime that he complains of. I am missing Part B of that, which requires him to set out the grounds on which the very suspicions that we have referenced are based. Do you find the grounds in this affidavit? Per suspicion.
May I just raise an issue
Yes, Chair.
with you, which is a legal question with regard to, you are looking at ABC.
Indeed, Chair.
Okay, that's the nature of, I'm looking at the introductory part of the section itself. If any person has reasonable grounds on which I would not go to ABC without first ensuring that that introductory part has itself been satisfied. And that I would do on the basis that this is an objective test.
Yes.
You and I do not have to rely on what Mr. Adams
Indeed.
subjectively thought.
Yes.
So I would start there. Were there reasonable grounds? But anyway, let me leave it.
My approach is slightly different.
So, but I'm just making.
Yes,
the point
I take the point.
I would not get to ABC before. But
I take the point, Chair, that's an approach, but I decided to adopt a different one. Here is IDEC having solicited an affidavit,
Yes.
receives the affidavit.
Yes.
Before a decision is taken, even for a preliminary investigation, that affidavit must comply with at least ABC.
Yes,
And
yes.
I conclude that the grounds advanced in terms of B would lead to the conclusion at the start of that, whether they are reasonable grounds. So it's sort of a reverse.
In the end, perhaps it works the same way.
Because I'm trying to test
Yes.
at which point, insofar as IDEC is concerned, a Section 27 referral dies
Yes.
for non-compliance, if ever there is such a point.
No, please go ahead, Ms.
Thank you, Chair.
Ms. Shalala.
Thank you,
Thank you.
So I'm now looking at 27B, and my reading of this affidavit is that it's replete with suspicions, but absolutely no grounds to support any of the suspicions advanced, unless you can find any that perhaps I may have missed. I adopted the approach I did to say, let's summarize and see if we can quantify the suspicions. So let's start with the suspicion at 2, that General Kumalo Lushaba Madondo and other senior crime intelligence officers were busy with the systematic capture of the crime intelligence division. Let's just sit with that one suspicion. Where in this affidavit do I find grounds to support that suspicion, which then would tick A and B of Section 27?
So, first, in paragraph 2, line 1, Commissioners, he says, so the cases he refers to above must refer to what follows. And he says the cases were opened based on information I received from time to time, which places the SAP's crime intelligence, and then it follows. So he receives information from time to time. And he then says in paragraph 3 that that suspicion became even clearer when an envelope pushed under his door at Parliament contained crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. So the grounds on which he bases it is information he receives. Information he receives from time to time, and further expounded by the fact that he has this envelope with further information that is pushed under his door. That is the genesis for the grounds on which his suspicion is
But
based.
you said he did not give IDEC that information which was slipped under his door.
That is correct.
So that's like saying, I have grounds, but I won't tell you what they are.
May I explain a further process that then happened? And sorry, Council, may I?
Absolutely, ma'am. By all means.
Because it might seem to jump the gun, but it will then perhaps provide more clarity. We received the Section 27. We received the dockets. IDEC takes the stance that an engagement has to happen with Mr. Adams because this 27 he did on his own and sent through to us. We have the dockets, but when they had the engagement, having read the dockets, having read the 27, it goes back to what I said. You then engage the person to see if there is other grounds that need to be covered. And further statements, Commissioners, were then taken in the engagements had with him in January of 2025.
I think where we are, Advocate Johnson, is that 27 says these things must be specified in the 27 affidavit. Because if you read 27, it says, by means of an affidavit or a firm declaration specifying ABC. So ABC are to be specified in the affidavit.
Correct.
They are not to be established at a later point. So the entry point is the affidavit which specifies A, B, and C.
And it is for those reasons, Commissioner Kumalo, that I referred to those two paragraphs. That is where I took that from, were opened based on information I received from time to time and the information placed under his door.
If perhaps you may assist us then. The suspicion is General Kumalo Lushaba and Madondo and others are busy with systematic capture of the Crime Intelligence Division. That's the suspicion. You are satisfied that that affidavit contains grounds to support that suspicion. Can you summarize those grounds for us?
With reference to the affidavit itself, right?
Indeed. Thank you, Commissioner.
On my reading, Counsel,
Yes, ma'am.
that suspicion is, he refers to the suspicion and he proceeds to explain, as he does in paragraph 4,
And what grounds are articulated in paragraph 4?
says that he suspects that General Kumalo and some senior officers in crime intelligence, including
I apologize. I thought we agreed that paragraph 4 contains other suspicions. I'm still looking for the grounds for the suspicion that Kumalo et al. Are busy with systematic capture of crime intelligence. Where are the grounds for that? The manipulation of procurement processes and processes to appoint is another suspicion. It's a different one.
Yes, and I'm saying that it is based on, I don't read it to mean that every single suspicion is supposed to have a ground. If my reading is incorrect,
No.
I'm saying that is how I read it. I read it as I received information from time to time. From that information I received from time to time, there are all of these allegations, inclusive of the documents under my door.
Okay. You wanted to invoke paragraph 4 to establish the grounds. Remember, we still have to comply with section 27B.
Yes.
So we're going to have to at least find the grounds for the suspicion reflected in paragraph 2. You say those grounds lie in paragraph 4. And if you could just summarize them quickly for us. And simply because my reading of paragraph 4 is slightly different, but I'll take your perspective.
So the suspicion of the systemic capture lies in his suspicions in paragraph 4 in terms of, he refers to the procurement, manipulation, for lack of a better description, manipulation of appointment processes, bypassing of the vetting. Those are the ones that talk to the systemic capture of the crime intelligence division.
He's not, in paragraph 4, and what you're referring to now, he's not giving you facts that support his suspicion, because that's what 27B requires, the basis for his suspicion. What he does in 4, on its terms, he says, I suspect, that which you're referring to now, he says, I suspect that General Kumalo and other senior officers in crime intelligence, including Madondo and Lushaba, were manipulating procurement processes and processes to appoint and promote certain members to higher positions. So it's a suspicion. So you can't say, when we ask you that, okay, he's made the suspicion to you, so let's say he complies with A, what are the grounds that he has stated in his affidavit in support of that suspicion? You can't say where he states manipulating processes, procurement processes and processes to appoint, and then you say those are the grounds. That's faulty reasoning. It is a suspicion on his terms. It is. He tells you, that's what I suspect. The question to you is, where in the affidavit did you find that he has put down grounds for that suspicion?
On my reading, Commissioner Baloy, it is found for those ones on paragraph 3, where he said, my suspicion about General Kumalo and others became more clearer when I found an envelope pushed under my office door at Parliament, which contained some crime intelligence procurement documents using secret funds of crime intelligence and vetting documents. I can take it no further than that is my reading of where he finds these suspicions.
Factual conclusion after factual conclusion, Advocate Johnson can never give you the facts that undergird those factual conclusions. All of the things you are addressing now are themselves factual conclusions. Do you understand what I'm saying? Do you understand what I'm saying?
If you could just take me back
Those
to-
are factual conclusions. Let me
Yes.
give you, let me give you agree. Do you agree?
I understand.
Those are factual conclusions. Do you agree?
I agree.
So if we go back to Ms. Sillo's question, she wants to understand what that factual substratum is. What facts do you rely on to say those factual conclusions, and you now accept that they are factual conclusions? What facts underlie those conclusions to lead to the fact that B of 27 is satisfied? On what basis? It cannot be on the conclusions. Let me give you an example. If someone says, I suspect that Tom and Dick killed Harry, that's a conclusion. For you to be satisfied that there is a reasonable suspicion that Tom and Dick killed Harry, there must be some substantiation before you say Tom and Dick killed Harry. Do you get me?
I understand. you.
Otherwise, it's a factual conclusion to say that Tom and Harry killed Dick. And I suggest to you that this is exactly what you are doing. You are relying on factual conclusions to say that B of Section 27 has been satisfied. Do you agree?
I agree.
You accept that proposition?
I accept your proposition.
Yes, Ms.
Thank you, Chair. And then, following that very same approach to all the concerns, I'm going to put it broad. Where in this affidavit do you find any grounds that can potentially get anywhere close to Section 27B? And I put it that way because I'm talking to a lawyer of 30 years experience who appreciates that when a statute prescribes what jurisdictional factors must exist before certain outcomes are achieved, you would understand that they have to be satisfied independently of one another. It's first A, the suspicion, B, the grounds. Where in this affidavit do you find the grounds that would satisfy the requirements of Section 27B?
I have referred to to those grounds and say that, having heard what the chair has indicated, there's nothing more than just what he said here. It is a matter of, he says, this is what I have, information and documentation. I think the question, and sorry, commissioners, I don't mean to be asking you all a question, but what I'm trying to pose for myself is, the question then is that sufficient for B?
Was there a sufficient factual substratum to satisfy B of Section 27? That's the question. And I think in response to my question, you've accepted that there was none.
In terms of the factual basis of it, yes.
The factual basis that undergirds or supports the factual conclusion.
Correct,
You've accepted that there was none.
yes.
Do you then accept on that basis, because my and your engagement has started on the basis of the first suspicion,
Yes.
which is state capture, would you accept that there is no factual basis advanced in this affidavit in respect of all the suspicions as you have identified them? Would that be correct?
That would be correct, except he says so of
His conclusions.
his conclusions of, I have information, and I receive information, and I also had information. It is
Now-
on that basis, yes.
If that's where we land, would such an affidavit comply with the requirements of Section 27? And what would be the consequences of non-compliance?
So given the questions that were posed by the chair, it was, I had not looked at it.
And not only the questions and the responses.
Yes. So on the basis thereof, commissioners, I've applied my mind differently. The commission has pointed something out quite differently that ought to have been considered. I'm saying in the manner in which I applied my mind at the time, based on how I understood Section B, or what Section B to mean, at the time, yes, I agreed that it fulfilled that requirement because he had knowledge. He had grounds on which it was based. I've given the answer, Commissioner. I can't change that answer.
Are you seriously telling us that since what you've been the director since 2022, is it?
Yes.
Are you telling us that since 2022, this is how you've understood your legal mandate, or
No.
IDEX legal mandate?
No.
Did I understand you correctly to suggest that you understood that the suspicion required has to be viewed subjectively? Did I understand you to say that? I'm asking you this because you said you believe that he had the required suspicion. He, Mr. Adams.
Yes.
Did I understand you correctly?
Correct.
So that's subjective as opposed to objective. So did you understand the test to be a subjective test as opposed to an objective test?
For me, the grounds on which the suspicion is based is a subjective test.
I will.
No,
okay.
I'm not going back on the argument.
okay,
I'm saying
okay,
in the way I've applied my mind, this is a reasonable suspicion
Yes.
that must be borne by a reasonable man and
Pers-
or
person.
by a reasonable person who must have access to knowledge and or information that brings them to that point. If you would allow me to just take it just a moment further.
Yes.
Mr. Adams is a member of the Police Portfolio Committee. These allegations come to them from time to time. There's active engagement with the police. There are documents that are shared. There's information that is shared. I did not take his to be just the test of a subjective mind of just a reasonable man.
No. You can't obfuscate issues in the manner in which you are saying. You said you considered the test to be subjective. Now you are saying something that suggests that somehow you also considered it to be objective. You cannot have it both ways. Please, Advocate Johnson. Let me ask you the question again. Did you consider the test to be subjective?
Correct.
Now, what are you saying? You've just said something that seems to suggest that you also considered it to be objective. Make me understand what you are saying.
Maybe I didn't express myself correctly. I'm saying that the reasonable man test, the person test, applies. But Adams...
Once, you see, therein lies the problem. Once you say that the test is subjective, then you look to what was going on in a specific person's mind. That's subjective. It has nothing to do with a reasonable person. That's subjective. You cannot have it both ways. Law 101 says subjective, you look to the person's mind. Objective, you test that in accordance with how a reasonable person would view the situation. The two are totally different. You cannot want to compound them. You simply cannot. You cannot say it's subjective, but then also refer to a reasonable person test. You cannot. I mean, even a law student doing first year would know that at a later stage during their first year of legal studies. In fact, across the board within legal studies, you go to your law of delict, you go to even criminal law, your culpable homicide, you encounter the reasonable test across the board. So how you could mix the subjective test and the objective test completely escapes me. So back to my question, you have said you accept, or rather you say the test under Section 27 is a subjective test. Do you stand by that? Because if you do, it raises very serious issues about your application of the section
27. Yes.
over all these years. Are you sticking to your assertion that the test is subjective, even though it uses reasonable? Once you have reasonable, that leads to the objective test. You should know that.
Yes.
Are you insisting that the test is subjective?
It is an objective test of the reasonable person.
It's an objective test.
Yes.
Yeah, you don't even need to go to reasonable person. Reasonable person is implied in the concept of an objective test. So you don't even need to go there. Now, if it is objective, did you operate, when you looked at this referral, did you operate on the basis that here I'm concerned with the objective test? Is that how you applied it? Because my sense when you responded to Ms. Sillo was that you thought it's subjective. And indeed, even here, until my 2 or so questions before now, you were saying it's subjective. It's subjective. So that must clearly mean that you looked at this referral affidavit on the basis that the test was subjective. Is that so? Is that so?
I looked at the section 27 on the test of the reason.
Subjective, it must be.
At the time, yes.
It must be, because that's what you believed. Hence, your answers on a few good times now during this engagement, your answers that the test is subjective. So you looked at this on the basis that it is subjective. You agree again?
Yes.
So
This one.
that means in your case, the word reasonable, which appears in so many words in section 27, did not come into the equation whatsoever. Is that so?
It does because
No,
of
it
the
couldn't.
first
Not if the test is subjective according to you. It wouldn't. Because once you talk reasonable, that takes you to the objective test. And you have said, in your mind, that did not apply. So you looked at this on the basis that it was the subjective test that applied, correct?
Correct?
So reasonable did not come into the equation to your mind, correct?
The reasonable that comes to mind is as per any person has reasonable grounds to suspect. It dealt with
But-
the offenses, which was part A.
It's there fine and you are reading it fine. But what I'm saying is, if you believe that the test is subjective, then reasonable, on your understanding, does not come into the equation. Because once you bring into the equation the word reasonable, that's already taking you to the objective test. You have said, on your understanding, the test was subjective. Therefore, reasonable would not have come into your equation, not on your approach. You must accept that.
I hear you, Commissioner.
Do you accept it?
I accept that.
Thank you.
Thank you, Chair. Based on the engagement you just had with the Chair, would it be a fair understanding that all your approaches to all Section 27 referrals you've had is the attitude you had to this particular one? So IDEC initiated investigations based on numerous of such affidavits which don't advance any grounds to support suspicions expressed therein. Has that been the case throughout the years you've been at IDEC?
No, ma'am.
And why then how have the other affidavits been dealt with? Have you interrogated their compliance with Section 27 before initiating an investigation?
Yes, the other affidavits were quite different. You'd also see, I think you requested from us the affidavit of a different witness. Yeah. When you read those as well, you can see the compliance with these sections.
Why didn't you bring to bear that particular need for compliance to this particular affidavit, which is dated less than 2 years ago, November 24? Why did you treat this affidavit as an exception to the rule that you say you had come to apply to all other Section 27 affidavits?
So I'm not going back.
Yes.
And I think that is where my fault line lay, is understanding what the reasonable person, and went back into subjective. That was my error. It is an error. It was an honest error. The test isn't subjective, the test is objective. Here I brought a subjective mind to bear on the information the person gave us.
And Advocate Johnson, that is apparent from paragraph 4, because Mr. Adams says none of these people were suitable to be appointed to the post. That's his personal view, without
Correct.
grounds to support that.
Correct.
He doesn't even say they did not meet the minimum criteria, they did not have the qualifications. He just says, you appointed somebody from BMW as a brigadier, and then he says, not suitable, full stop. Why are they not suitable? Do they not meet the qualifications? He does not even identify the offense that he suspects. is being committed there. Because appointment of somebody from BMW on its own does not tell you anything. Because my immediate question would be, what is wrong with appointing somebody, an engineer from BMW? If the position required an engineer, what would be wrong with that?
Correct.
That would be my immediate question. And I would need that to be addressed in the affidavit itself. Because the entry point, according to Section 27, is that the affidavit must specify 1, 2, 3. Not that it must set out the suspicion and then the grounds, IDEC will figure them out for itself.
Understood.
Just on an answer you gave in response to Ms. Sillo,
Yes,
you
sir.
said an error that you committed was not to apply was to apply the subjective test. The test is in fact objective. In that response, based on the answers you gave to me, and repeating the same thing a good few times throughout until your engagement with me, the distinct impression I got was that you've always understood the test to be subjective. Correct?
I understood the test to be the a reasonable person test, which is an objective test.
Okay, I will not go back. I engaged you on the subjective and so on because you cannot marry subjective and objective. It simply can. Oh, let me ask you this question. So throughout, your understanding of Section 27 was in accordance with the responses you gave when I engaged you. As to what those were, the transcript will assist us. Throughout, that was your understanding. It is only now that you have clarity as to what exactly the test is. That is a test which is not subjective as you suggested it was, or a test which does not seek to mix a subjective and objective test. It is simply objective. So before now, you had, I feel bad to have to use this word, but your understanding was this muddled view of what the test was, which muddled view came out as I engaged you. So that was your understanding until now, until during this engagement. Is that a fair suggestion to you?
It is fair.
Thank you.
Can I just say, Ms. Johnson, that even allowing for it was an error, you applied the subjective test because of your misunderstanding of the test that applies. Even on that, in this affidavit, insofar as 27B requires him to set out grounds, this affidavit doesn't set out any grounds. To say I received an envelope that has procurement matters, that's not a ground. It doesn't tell you anything about the contents of the envelope. For all I care, those procurement documents may well not demonstrate anything wrong. So it's not clear to me when you say, well, I accepted because he's a member of parliament who serves in the portfolio committee, that when he says he has an envelope that is sufficient. You surely must know and understand that for you to say this falls within our mandate, you need to satisfy yourself with whatever it is he's relying on. So I don't accept that what you say is an error on your part of applying the wrong test, that it explains what happened here. It doesn't. Even on that error, I would expect you, as you understand the section, it says he must set out grounds, and he doesn't. He doesn't. When he goes on to say 4 other colonels who qualified, or who are employed in crime intelligence, none of them were suitable to be appointed in this post. It doesn't tell you anything about this candidate that was appointed. It doesn't. So it is clear in 27B that he does need to tell you facts. Subjectively, he thinks those facts meet the test, but you have to know those facts before you say, yes, our mandate is triggered. You must agree with me. I must be correct in what I'm saying.
I'm not about to disagree.
Okay, thank you.
Thank you, Chair. I see it's 12:59, but it'll be an opportune time to take a lunch adjournment. Thank you.
Thank you, Ms. Lilo. Let's adjourn and come back at 2 p.m.
Thank you.
1, 2. We are ready to resume. Please make sure that your cell phones are off. Thank you.
Yes, Ms. Silva.
Thank you, Chair. Chair, before we continue with the witness this afternoon, Advocate Johnson has made a request to us as evidence leaders, which request I table to the commissioners for consideration. Advocate Johnson has requested that we sit until 4, but may she be excused at 3 this afternoon. She's, as the Chair is aware, currently on medication following her illness last week. And I'm made to understand that the medication she's on is having some debilitating effect on her. So she has requested an early stand down today at 3 o'clock.
I confirm that, Chair. There was that communicated to me by Ms. Johnson. I communicated it to Ms. Sello, and that's where we are. Thank you.
Thank you, Mr. Lo. Thank you, Mr. Bodlani. We will adjourn at 3 p.m. then.
Thank you, Chair.
Thank you.
Ms. Johnson, then we have an hour to run through some of the issues we had wanted to engage you with on today. I hope you feel better tomorrow.
Thank you, and thank you, Chair.
Thank you. We had just looked at the affidavit and its compliance or the lack thereof with Section 27. So now we're at a point where you are in receipt of this affidavit. Can you take the commissioners through every step you took regarding this affidavit, any discussions you had, and with whom, until the point of the 6th of December when you say you took a decision to refer the matter for a preliminary investigation? Thank you.
Maybe before you do that, let's remember earlier we discussed that after you received the letter from the minister's office, you then spoke to Mr. Perumal,
Correct.
who then took it from there. Now, when Mr. Perumal, after you speak to him and he takes it from there, does he come back to you to say anything before we get to this point of the Section 27 affidavit?
Commissioner Baloy, what he does come back and say, the gist of which is he has communicated with Mr. Adams. Mr. Adams indicated that he had reported these 4 dockets that we see in the letter. He informed Mr. Adams that as per IDEC, if you want IDEC to look at a matter, you would have to depose to a Section 27 affidavit. He told him it would be best if he maybe sat with a legal representative, told him where to find the provisions of Section 27, and for him to then, should he still be of a mind, to then depose to an affidavit. That is where that part stopped, and then on the 21st of November, we were in fact then furnished with the Section 27 referral, which is currently in the at least part of the bundle.
Okay, thank you. Then back to Ms. Sello's question then.
Thank you, Commissioner.
Perhaps for my benefit as well, please repeat
Absolutely.
the
question was, we have just very quickly looked at the contents of Section 27 affidavit. And as I understand from the witness's testimony, she has seen it and perhaps has engaged with the affidavit. We are aware that on the 6th of December 2024, she took a decision to initiate a preliminary investigation based on the affidavit. So I would like her to inform the commissioners of the steps she took subsequent to the receipt and consideration of this affidavit up until she took that decision.
Thank you. May I find out if you will be dealing with his reason to suspect at some stage? I'm not pushing you there, not now.
Yes.
His reason to suspect in 28(1)(a). A at some stage?
Yes,
All right.
I intend to do so.
Thank you, thank you.
Chair.
Please respond to the question, Ms. Johnson.
Thank you, Chair. Oh, I received the Section 27 referral. Once I received the referral, I myself perused the referral. I then decided to give the referral to the team of Advocate Manilal. At the time, I can't recall where he was, but I gave it to the advocate in his team, which is Advocate Ramsamy. The purpose is, as was explained previously, that once you allocate it to a team, commissioners, they would then peruse, see whether there's sufficiency, what next steps must flow. Ms. Ramsamy, Advocate Ramsamy then perused the Section 27 and brought a Section 2813 application. And the purpose, sorry.
Can I just interrupt you before you speak to the purpose? You haven't said anything about Mr. Sissoko. Is it
That is
because
correct.
at that time he's not featured?
It's not featured, and because this was really, some of the 27s are really voluminous, and I like that two-mind approach. This was just a small document where I could quickly apply my mind. And I looked at it and said, let me give it to a team as we would then ordinarily do, because on the face of it, there were offenses that fell within the mandate. I gave it to Advocate Ramsamy, who then perused the Section 27. She realized that there were references made to dockets, and because we didn't have those dockets, the best way, instead of asking Mr. Adams to amplify the 27, as one would ordinarily have done, is to first get these dockets, because he's talking to allegations in these dockets, and he makes reference thereto. So in order to get those, sorry, Council.
No, please proceed. Never mind me.
No.
No, continue. I don't intend to interrupt at all.
Okay.
Thank you.
And in doing that, she applied for a Section 2813, which is a preliminary investigation, on the 6th of December. It was a mechanism, commissioners, for us to then have an authorized investigation in order for us to now determine where these dockets were. Bearing in mind that Mr. Adams has already alluded to the fact that in Cape Town, these dockets were no longer there. He makes allegations. But he then says he opened dockets in Gauteng. So there's no need for us to go to Cape Town. If you open similar dockets in Gauteng, we engage then with detectives in Gauteng. It would have been one of the investigators, it would either have been Mr. Perumal or Mr. Rapeso, who indicated that we need to write a letter to the head of the detectives in Gauteng, who was a Major General Khumalo. It is a formal approach in terms of acquiring those dockets. I did pen a letter under my hand to the Major General, indicating that IDEC was now vested with an investigation and would require the dockets as per the letter, which were the dockets that were referred to in the minister's letter and subsequently by Mr. Adams.
But by this stage, you have now made a decision that IDEC is investigating this matter. By the time you are now asking for dockets.
A preliminary investigation, yes.
Okay.
And a preliminary investigation, if I may, is it might pan out to nothing. That is why it is safer to have done a preliminary investigation, because not knowing what's in the dockets, it could be a futile exercise having a full investigation, using all of the time and resources, and find that actually it's insubstantial to support.
And you did this in terms of section 2813,
1-3, Chair.
section
Yes.
2813. All
Thank
right,
you.
thank you.
Thank you, Chair. In the morning, I had understood that your approach to the head of detectives, I think you said General Kumalo.
Major General Khumalo.
Khumalo, was requesting the dockets was on the 6th of December.
That is correct.
That is the same day a decision was taken to authorize a preliminary
That is
investigation. So it can be on the 6th of December that Advocate Ramsamy made an application, because you are only making a decision on the 6th of September to initiate at 2813 in preliminary investigation.
The authorization was dated the 6th.
That's
She
your
would-
authorization.
My authorization. She would have given me the papers prior. I just can't tell you which day prior to the 6th.
What papers would she have given you in this regard?
So it is an application for an authorization, which the ID must consider to approve. So she wouldn't have given it to me on the day to approve on the day.
So at the time she gives you whatever application she does, what is she armed with?
She would have been armed with the section 27.
She also, at least she got a copy.
She had the 27.
Okay.
Yes, ma'am.
Now, I think it was yesterday or this morning, I came to understand, and maybe I was wrong in my understanding, that prior to the 6th, you and Mr. Sissoko, I thought you said, engaged extensively over this Section 27 affidavit, on the basis of which you then took the decision you did on the 6th of December. Now, in the narrative you just provided, you haven't said anything about your engagements with Mr. Sissoko.
The chair did ask earlier. I said in most of them, I would engage with Mr. Sissoko. This was a very small section 27. I don't have to give him. It is a practice I do, and usually with the more bulky ones, they have been on the off case or off chance where it's really a small, not small, it's not nice to say small. It might not be substantial, and I am able to go through it myself, apply my mind, and make a decision.
So are you suggesting my understanding all this time has been wrong, that you engaged with Mr. Sissoko on this particular referral? Because that's what I had understood from your testimony.
I didn't engage him on this referral.
It's not, Ms. Law, it's not a misunderstanding. It's what you said throughout, that you did consult with him. If you recall, even yesterday, when I said to you that Colonel Parayaki spoke of a committee, an intake committee, and you said, well, on paper we have it, but we haven't yet implemented it. And so what I do, this is what you said, what I do is I receive it, I consider it, I form a view, I give to Sissoko, and he then took that into account, and he came back to me, and we agreed that this falls within our mandate. That was your testimony yesterday. So it's not a case of misunderstanding, it's you are revising what you said to us yesterday.
Sorry, if I created the wrong, I meant when we talked about the intake committee, I was trying to explain that there is no committee, how the Section 27s worked. So if I created that impression or it's incorrect, I did not share the Section 27 with Mr. Sissoko.
So too then was Colonel Padiachi wrong in testifying that the briefing was given to the team by Chief Perumal after the case management committee had considered the Section 27. That's utterly wrong.
No, that's wrong.
Because you are not a committee, you are one person.
We are not a committee.
Yes.
And sorry, Chair, I did indicate yesterday, there is no committee, and I cannot call Mr. Sissoko and I a committee. I give it to him because he's an investigator, and with me being a prosecutor, it helps that perspective. But there is no committee at the moment that deals with any of the 27s as they come in.
And it might be a speculation on your part, but What could possibly have led Colonel Padiachi to conclude that the investigation referred to the team was following a decision by a committee? What could have?
I think I alluded to yesterday that we're in the process of putting together a draft standard operating procedure manual. It is one of the things that is proposed in the manual, but it is not implemented currently or in effect.
Okay.
I think I did allude to that yesterday.
So please have regard then to Section 27. Seeing as you are the person who received the Section 27 referral, who considered it, I think now we, at that point, the question the chair wanted to engage you on, is it correct to say that on your reading of that affidavit, you considered that there were reasonable grounds to proceed with this investigation?
Correct.
That's what you consider. On what basis?
So there were reasonable grounds for us to consider the matter based on the allegations made out.
Just the suspicions,
Just
and
the
nothing
reasonable
more.
suspicions.
And at that juncture, you had nothing but the Section 27.
That is correct.
And then if we go to Section 28:13, that section provides, if the investigating director considers it necessary to hear evidence in order to enable him or her to determine if there are reasonable grounds to conduct an investigation in terms of subsection 1A, the investigating director may hold a preparatory investigation. So by this point, you had, based on just the affidavit, you considered necessary to hear evidence on these suspicions.
That is correct. And the here evidence is not of necessity oral evidence. It's getting the evidence to support, if there is, in fact, to support those reasonable grounds.
But what do you make of the word here, open quote here evidence? What do you make of just that word here?
Is the conducting of the interview with the witnesses,
Okay.
prospective witnesses.
Okay.
And thank you, Chair.
And that be a formal process, a recorded process,
It
those
can
interviews.
be a recorded process, yes. More often than not, the 28s are a recorded process, or it is an interview process,
Yes.
and then the statement is taken.
Yeah, but what I'm asking is, in what happened in that interview, there must be a record of it.
There should be a record of it, yes.
On this day, so-and-so met with Mr. Adams at Pretoria from this time to that time. This is what was discussed. Yes, it will culminate in a statement, but there is a recorder.
There should be a
of
recording,
what
yes.
happened. Thank you.
Yes.
And you know this for a fact.
No,
We don't want
no.
you, we don't
I'm saying
want,
that is
sorry,
I said-
just a minute. We don't want you going back on what you've just said in response to my colleague, Commissioner Barry.
I did say, Chair, there should be a recording. I will confirm that whether or not there was a recording. They
When you
must-
say,
they
when you
should.
say there should be, are you referring to this instance, or are you saying there should be a recording generally, as a general statement?
In these matters, generally, there is a recording.
So there is a recording.
A recording, yes.
As a matter of course.
As a
there
matter
is-
of course.
There is a recording.
Yes.
All right, all right. May I just ask one?
Absolutely, Chair. Thank you.
The section 2813 hearing of evidence, let me loosely call it that. Surely that the need for that does not undo the requirements of section 27. Section 27 must have been satisfied. The requirements of 27 must have been satisfied. You cannot, if the affidavit does not meet those requirements, you cannot get to 2813. Is that correct? Do you agree?
That is correct, Chair.
Thank you. So basically, as you would have learnt in your administrative law, those are the jurisdictional facts for, or to trigger anything that gets done under 28.
Correct.
Those are the jurisdictional facts.
Correct.
Thank you, thank you.
Just one from me. To hear evidence under subsection 13, do you have to summon the witnesses who are going to give that evidence? Do you have to issue a summons to Mr. Adams, for example? How do you hear the evidence in the absence of a summons?
There are oftentimes, Commissioner Khumalo, where you contact the person and they are prepared to come in, or where they do not want to come in, then you do issue the summons in terms of section 28.
So in this specific case, what happened?
In this specific case, Mr. Adams was contacted, he was prepared to cooperate, and the investigators and a prosecutor then went ahead to interview him.
Ma'am, now it works. Now it works. Ms. Johnson, can we have a record of that section 2813 process that you say happened? Can we just have a complete record of that?
For this,
Yes, that 2813 process.
that would have happened with
Yes.
Adams in January.
Yes, thank you.
Thank you, Commissioners. So, I think earlier, oh, sorry. She's still writing.
Thank you.
You made a note. Okay. Earlier, you indicated that Advocate Ramsamy prepared the section 2813 application.
Correct.
We don't have a copy of that application. Are you able to provide one?
May I just check with my advocate Marga if they didn't ask for the section 2813?
No, we
Is it
hadn't
not?
requested it in the subpoena. It's not one of the subpoena documents. So
But we
I'm saying,
request-
now that you
request
reference it, are you able to provide us with a copy? So then if I understand your testimony, you give an instruction to Advocate Ramsamy and the Section 27 affidavit,
Correct.
and you want Advocate Ramsamy to make an application back to you in terms of Section 2813. Please explain how that works.
I have applied my mind to the section 27,
Yes.
but I have to give it to a team to also apply their mind and to see whether or not an investigation can be instituted. I took the view at the time that it fell within the mandate of IDEC. But in terms of the prescripts, no investigations can happen if you are unable to comply with an application for an investigation. So we hand it over to the prosecutor, who must look at the 27. She didn't have to apply for a 2813. If she then, after having assessed it, decided it does not fulfill all the requirements. It is consider this matter, and if you agree that it falls within the mandate, we are all lawyers to apply our minds, then please lodge a section 28 application. She decided to lodge a section 2813 application.
You said the first part, you give it to the prosecutor and ask her to apply her mind to the Section 27 affidavit, and then express an opinion to you, and then thereafter she lodges an application. Is that correct?
Instead of an opinion, if you agree that it falls within the mandate, you then apply for a section 28.
Okay. Where is that? Was that your instruction to her? here is a Section 27 affidavit, consider it. If you agree that it at least discloses a basis for a preliminary investigation, please provide me with a Section 2813 application. Is that more or less how
A
it
Section
goes?
28 application,
Is
yes.
that how it normally happens?
That is how I recall it happens, yes.
Did its Advocate Ramsamy ever express a view to you on the content and depth of the Section 27 affidavit? Did she ever express her views on that affidavit?
No, when she brought the Section 28 application, I realized that she agreed with the contents of the Section 27.
And she never expressed a different view that it's deficient, it doesn't comply? No, she didn't?
No.
She also didn't pick up the fact that it doesn't comply with Section 27?
No.
She didn't. Commissioners, yes, please go ahead.
This application, it's made in terms of what? Because my reading of 13, and it may well be that there's another section to read before I get to 13, but my reading of 13 seems to contemplate that you, for example, upon receipt of that Mr. Adams' Section 27, if you determined on the face of it that it is necessary to hear evidence, you would proceed to instruct that such a process should happen. Where do we see that Ms. Ramsamy had to make an application before that inquiry, that hearing of evidence could be held? I wouldn't have a difficulty reading 13 if you said, I looked at this affidavit and determined that we need to hear more, and then I authorized a preparatory investigation. I wouldn't have a difficulty with that because I read 13 to empower you to do that. But you speak of a more involved process where you make the determination that this falls within our mandate, you give it to somebody else for their opinion and execute, and then you say to them, if you think we must do a preparatory investigation, bring that application, and I'd like to see where is that contained, that step.
So I take it, Commissioner Baloy, from the section that I had referred to, which was the Section 2813, if the investigating director considers it necessary to hear evidence in order to enable him or her to determine if there are reasonable grounds to conduct an investigation in terms of subsection 1A, the investigating director may hold a preparatory investigation. That is where we take it from.
No, I'm not questioning that you could convene the hearing of evidence, or you can convene a preparatory investigation or hold a preparatory investigation. I'm not taking quarrel with that. I accept that in terms of 13 you have the power. I'm just trying to understand this process that you've just described to Ms. Sillo, where you get the Section 27, you look at it, you make a determination that it falls within, what is raised there falls within your mandate, so you should investigate. And then you give it to Ms. Ramsamy, you give it to the team, I assume
Yes.
at that point to execute. But I understood you to say to Ms. Sillo that in that discussion with Ms. Ramsamy, you said to her, look at it, if you think it's necessary to hold a preparatory investigation, make an application. That's what I understood you to say.
Look at it and see if it is necessary to make a Section 28 application.
Yes.
Yes.
Then my question is, a Section 28 application in terms of what? Is this a practice? Is this one of those where in your office, you have ways of doing things. I mean, you have encountered these subsection 13 many, many times. So if it was in the Act, I think if that requirement to apply to you, if it was in the Act, I would have expected you would go straight to it because it's something that you encounter every day. If you are not able to find it, can we conclude that this is one of those instances where you practice things, you have ways of doing things, they are just not written down?
That are procedural based on the requirements of what would initiate an investigation.
Yes, so it's not written down anywhere, you just have a practice in the office?
It is a practice, yes.
Thank you.
Both 27 and 28. So if you look at the main body of 27 and 28.1, because those are the two sections that take you to 28.13.
Yes.
For you to determine that what is reported to IDEC falls within your mandate, there must be a reasonable suspicion or reasonable grounds to suspect that a specified offense has been committed. So in what was presented to you, what is that specified offense that you looked at and then said this falls within our mandate?
In terms of the 27?
Both 27 and 28, because that's where you start.
Yes.
Chair has engaged you on the test, subjective, objective. We've moved past that. Something further must exist, and that is a suspicion that a specified offense has been committed or is being committed, or there's an attempt to commit such an offense. So what is the specified offense here that made you believe that this falls within IDEC's mandate?
It would have been where the procurement portion was. It was contraventions of PFMA and or fraud, where the siphoning of the monies and or that was the theft and the financial crime with the money laundering aspect, and where the issues of the vetting and the appointments, it was in the way that it was couched, the capture of those systems and processes.
So are those specified offenses as contemplated in 27 and 28?
Those are the offenses as set out in Section 7 of the Act that set out the offenses that IDEC falls within IDEC's
no, that's
mandate.
a different question. 27 and 28.1 do not say any offense. Unless you read specified offense in 27 and 28.1 to mean any offense referred to
In Section 7.
in Section 7. Is that how you read it?
Yes. Because we have no other offenses. That specified offense is the one that was deleted. And they didn't.
So let's just be clear then. So your determination was that because these offenses are offenses referred to in Section 7, sub 1, capital A, that is good enough.
Correct, Chair.
Even if they are not specified offenses as contemplated in this statute.
Yes,
As
because
far as you were concerned, you still had a mandate to investigate them.
that is correct.
And that was your understanding.
Correct.
Okay.
Thank you, Commissioners. And you then subsequently received, I take it, the Section 28.13 application from Advocate Ramsamy, and then you authorized the preliminary investigation
That is correct.
on the 6th of December. Prior to your authorization, is there any investigation that Advocate Ramsamy or member of her team undertakes? Or does she apply her mind to the Section 27 affidavit and perhaps the law, and then drafts the application in terms of 28.13, meaning she doesn't seek to obtain documents extraneous to the affidavit?
Correct.
So she works purely on the affidavit
That is correct.
and forms a view.
Correct.
Okay. Now, this morning, As I think Mr. Bodlani indicated, documents were forwarded to the Commission as part of the subpoena requests made. And these have been received, we confirm. In a moment, we'll be turning to them. Yes, no, I hadn't. I said I will be referring you to something. The commissioners will recall that this morning I referenced documents that were requested. Yesterday I indicated that they had started trickling in. And Advocate Johnson read off some documents she had at hand, and she indicated that they've been provided to us. And Mr. Bodlani confirmed that. The documents have been received, and I'd like to, they should be included in your files. I pray they are. We are now in file 8. And I'm interested in particular.
Should we put away those we were using this morning? Or not really?
Judging
Not
by the
at-
time, yes, I think so. Considering we're ending at 3, yes.
Because there's quite a clutter in front
I
of us.
can well imagine. I apologize. Yeah, except for the file containing the referral affidavit, file 2, page 512. Thank you, Chair. Thank you, Commissioners. In particular, I wanted us to go to page 3282. That is the authorization in terms of Section 28, sub 13 of the NPA Act. Advocate Johnson, I need us to put a finger on that page and that file. Please don't close it. And let's go back to the referral affidavit. That would be file 2, page 512. Now, in this affidavit, I note at paragraph 2,
Sorry, 512.
512 of file 2. Help is coming.
This is file 2. Why do we not have a?
Page 512.
I don't know why I'm not.
The referral affidavit.
Yes,
Yes.
I had given the file back. I'm not sure why I'm not seeing it.
Did you perhaps, because of the clutter around you, did you take it out of the file?
No. No, I didn't take it out of the file. File 3.
May I request your counsel to, I don't know how many copies they have available, of the referral affidavit, page 512 of file 2. And for your purposes, Mr. Bodlani, we will be flighting it, so you'll follow it on the screen, if you could. Thank you so much.
Apologies. Thank you, Council.
My pleasure, Member. Now, if we go to paragraph 2, on this affidavit, I see concerns regarding General Kumalo, General Lushaba, General Madondo. You see that?
I see that.
And overleaf at paragraph 4, that's the suspicion regarding manipulation of procurement processes. At second sentence of that paragraph, I see it says, I suspect that General Kumalo and other senior officers in crime intelligence, including Madondo and Lushaba, were manipulating procurement processes to appoint and promote certain members. You see where I'm reading?
Yes, ma'am.
If we drop further down in that paragraph, fourth line from the bottom, once again, it speaks of persons being appointed to strategic positions, and that such persons are suspected to be loyal and close to Kumalo, Lushaba, and Madondo, and those close to them. I go over leaf at 5. I see reference to General Kumalo, where an allegation is made about the former Minister of Police, Minister Cele. And as we know, paragraph 6 concerns General Lushaba and the theft that occurred at his home. Paragraph 7, once again, it's Kumalo, Lushaba, and Madondo. And I think that's about, then we get to paragraph 8 and 9 and 10, which are concluding paragraphs of that affidavit. You confirm that?
Correct.
Now, this is the same affidavit that Advocate Ramsamy was armed with.
Yes.
Now, let's get back to our file 8, page 3282.
Got it.
Now, at 3282, that's an authorization signed by you. If you look at 3283, it's dated the 6th of December, 2024.
Correct.
And in the first page, you say, I, Andrea Johnson, and you continue regarding your authority. And you indicate that you have reason to suspect that the following offenses have been committed, and you list them. Am I reading your authorization correctly?
Yes.
So these are all the offenses,
Yes, all the possible offenses.
possible offenses. And you clarify that over leaflet 3283, where you state that these have been committed or are being committed, or attempts have or are being made to commit such offenses in an organized fashion by inter alia, the persons or entities in the annexures to be the institution of the investigation in terms of section 2813 of the Act in relation to the activities of South African police services and crime intelligence and any other entity. My question is, that conclusion you draw, that litany of crimes has been committed or being committed or attempts have been made, that can only derive from the Section 27 affidavit.
Correct.
What in the Section 25 affidavit leads you to the conclusion that the crimes listed in there, all or any, have been committed or were being in the process of being committed?
The Prevention and Combating of Corrupt Activities Act falls within the ambit of the allegations in paragraph 4.
Paragraph 4,
Yes.
noted.
not knowing what all would have happened in the alleged placement and appointment of persons. So he couldn't rule out the corruption. The Prevention of Organized Crime Act would relate to paragraph 4 and likely points to the laundering of money out of crime intelligence.
Yes.
The National Strategic Intelligence Act would relate to the vetting issues.
Okay.
And the Secret Services account relates to the allegation of paragraph, at the end of paragraph 3, the use of secret funds, and then there is the further allegation in paragraph 5, some of the funds became taken unlawfully from the secret funds account. So wherever there was a relationship with the secret funds account, that act becomes applicable. The procurement fraud, the alleged procurement fraud under the Public Finance Management Act, the Financial Intelligence Center Act also relates in part, just want to get there. To paragraph 7.
Yes.
And then the contravention of the Police Act because of the appointments and the vetting that is referred to. And then the allegations of fraud, theft, forgery and uttering and or defeating, obstructing the administration of justice, which would relate in part to, not in part, in the main to the charges against General Lushaba.
Okay, now, what would be the theft? What would relate to the theft here?
The theft was the actively siphoning money from the Secret Service account.
Okay.
And then there was the one...
and the forgery and
I
uttering?
suspect that funds became taken unlawfully from the Secret Service funds account under paragraph 5.
Thank you. And the forgery and uttering?
That would have been in relation to manipulating of the procurement processes and processes for the appointment, that there could be allegations there of forgery and uttering.
How do we start with manipulation of processes and then we suggest that there was forgery or that manipulation involved forgery? Because the process could have been manipulated in so many different, 1,000 ways. How do you land on forgery and uttering?
It is a possible offense.
Okay.
Yes. No. So perhaps, if you would allow me to just say, is that these are the offenses that one is looking at. They are not open nor are they limited in terms of you go with what you have, but if you don't put in the possibility, usually when you have fraud and or theft, there often does happen to be forgery and uttering. And so if you haven't listed that offense, it might become a challenge later on.
So this is a list of all possible crimes
Within the ambit of the 27.
of the 27?
Yes.
And you so maintain?
Yes.
Okay.
Please define forgery.
It is where, in terms of, for example, with the documents, that someone would have forged someone's signature either in the procurement documents, in the appointment documents, or in the vetting documents. It purely relates to the forgery in terms of putting in.
And there was a basis for suspecting that this had a reasonable suspicion that this had happened?
Reading it in its totality,
Would there be a reasonable suspicion that this had happened?
correct.
On what basis?
That if
Is there anybody who ever suggested that documents had been forged? For example, that certain people had signed documents purporting to be other people?
that has come afterwards in the investigation, yes.
Yeah, the question is,
In this
at
instance,
this point, when
yes.
you're writing this document,
Yes, that,
what were you relying on to get to the point where you say forgery and uttering is implicated?
I read it, Commissioner Baloy, in paragraph 4, where we talk of the manipulating of procurement processes and processes to appoint and promote certain members to high strategic positions within the crime intelligence, that in that manipulation, there can be fraud, forgery, or uttering.
Speaking for myself, I don't see how that takes you to forgery. Remember, you've said in the introductory part, before you itemize the offenses you referred to, you have said you have open quote reason, close quote, to suspect. I don't see the reason for you to suspect in what you've said thus far. I just do not.
I take your point.
Thank
This is
you.
what I've got.
Thank you, thank you.
Thank you, Commissioners. Then just to conclude, at 3283, having then itemized those crimes, you say those offenses are being committed or have been committed by, I'm reading the second line, persons or entities in the annexure. Now that annexure appears at 3284. Overleaf. That's the annexure. Now, we have General Kumalo, the General Madondo, General Lushaba, and a list of others. I know, as I indicated to you, that the Section 27 affidavit specifically identifies General Kumalo, General Madondo, and General Lushaba. We just did that exercise at the various paragraphs 2-4. I cannot find in the Section 27 the persons identified under items 4 to 12. And you recall that your testimony was, all you had at the time was the Section 27 affidavit. Does not reference any of the people listed from 4 till 12. Where does your annexure get them from?
Johnson, I think the question is, who gave you these names? They're not in the affidavit. We can look at it for the next hour. You will not find the names in 4 up to 12. Somebody gave them to you. Who gave you these names? And under what circumstances?
This application came to me from the prosecutor.
So Ms. Ramsame will have to tell us where she got these names from.
That would be correct.
Okay.
Did you inquire from her where she got the names from when you know that you only gave her the Section 27 affidavit and you are quite familiar with it?
Yes,
Do you engage and say, who are these ones now? Where do they come in? How do they come in? They are not in the affidavit. You are not conducting an investigation yet, so you are not obtaining your own evidence. Where do these names come from? Did you have that engagement with her?
I didn't have that.
Why not? Shouldn't you have? Because from what you are suggesting, it's like she looked at those 3 names and said, no, 3 is not a good number, I prefer 12, and start like somarhoying other names in there. And you signed, and you are happy with that. How come?
As I indicated, according to me, she only had the 27.
Yes.
And she would have then put together the 28.
Yes,
Yes,
which we're looking at.
yes,
And you know the 27 doesn't contain the names from 4 to 12.
that is correct.
So why do you sign it in the form that it is, where suddenly it includes a litany of other people who are not mentioned in 27 affidavit?
Brigadier Mokwele is there, sorry. Council, you refer to only the first 4?
The first 3,
First three.
The first 3.
yes.
Sorry, Commissioner Baloy, that I'm now a bit slow. And I don't intend taking the whole afternoon to.
Well,
To read,
I'm just trying to be helpful.
I know,
Because
I'm trying to figure out how she would have arrived at the names because their official capacity is mentioned, but the names are not mentioned. I take the point.
you accept that it is not from the
27.
Section 27
Yes.
affidavit that
Yes.
she got the names.
Yes.
You accept that someone must have, if they come from her, someone must have given her these names.
Correct.
Yes.
And I will find out.
And you accept that at this point, when she approaches you with this application, the investigation hasn't started yet. You
That
gave her the affidavit, she looked at it, and she came back to you
That is
and
correct.
said, we need to have a preliminary investigation. So you accept at this point, there's no investigation yet.
Correct.
All right, thank you.
My challenge is this, Advocate Johnson. You are authorizing an investigation into 8 people who are not mentioned in the singular document you have. They are not referred to you. There's no complaint regarding them. But you are authorizing an investigation into them. In terms of what section are you acting in so doing?
A conversation must have happened
With who?
Sure.
That's the question.
with Advocate Ramsamy.
No, she's not conversing by her soul self. Who is she conversing with?
What I'm saying is, she and I must have had a conversation.
Oh, so you are aware of
I'm
them?
saying she and I must have had a conversation, and I will follow that up, because I don't have an independent recollection of a conversation. And she would have to indicate then if she had a conversation with somebody else. I wouldn't just have blindly signed it without finding out from her.
Did you perhaps suggest these names to her?
No, these are not people I know.
Can I say that the difficulty is that you don't seem to abide the terms of this Section 27. Even if she proposes the names to you, you are the final decision maker, you are the in charge. You're the one that's authorizing an investigation. It's difficult to conceive of a situation where she comes back to you and she gives you a list of names and you don't say, no, we can't do that because it doesn't arise from this affidavit. We haven't started an investigation, so I know you didn't get those names from an investigation. I know you didn't do that. We have at this point only this affidavit. And you don't say, we are obliged to work with what we've got. We can't do whatever we feel like. It's difficult to understand that you would be party. If this is her giving, she gave you these names, that you are happy to sign off a truly invasive investigation, because your powers to hear evidence means you can call these people, you can look into their affairs. That's what it means. And you do it outside the corners of the only document you have on which you could work with. You, the head, are not in a position, and you do not say to your prosecutor that we are not doing that. We are bound by law, we are bound by rules to investigate that which is properly given to us. It's a misuse of powers, whether it comes from her or from you. At this stage, this is a misuse of powers to take intrusive steps and action against people on this affidavit. You have no justification whatsoever on this affidavit to be looking into Likalakala, Ngube, Moyani, Sibula, Madileng, Mokwele even, by name, Duvalo, whoever is automotive engineer. You have absolutely no legitimate and valid basis to look into them. Maybe there is something to look at later on, but we are still at this affidavit stage where you are authorizing that they be called in, that their affairs, their bank statements be looked into, and their lifestyles and everything and about them. And they must come to interviews under threat of, if you do not cooperate, it's a criminal offense. You're happy to do all of that, when in fact the document, the only document on which you rely to act as you do in this document, doesn't create a basis for it. It's to me, it's yet another instance where you, in particular, have misused your powers to go where you are not authorized to go. There's no legitimate basis to do this. Do you want to comment?
No, I have no comment, Chair.
Thank you.
Advocate Silo, you can clarify it, or Advocate Johnson can clarify it. Maybe I'm too slow now. Before this authorization, I thought there's an application, then the authorization, or does the application come after? Or maybe you can answer.
Yes,
it.
yes,
I had
because
understood that what should
understand both.
precede this authorization is an application.
That is correct.
Then this authorization authorizes the application.
That is correct.
Now, can you show us where that application is? Because
So
it
it's
may be
not-
that the questions you are being asked, the names were in the application.
I say that it's not part of, I don't see it here. And I will ask that they make the application available.
Okay.
I'm not sure why the application is not with the authorization.
The one that I see here, I suspect you're going to be dealing with it later, so I don't want to go
Yes,
there.
that's a different authorization
Yes,
now.
yeah.
Yes, it's not the 2813 authorization. Thank you. Chair, it's 1502, as I'd indicated.
Let us adjourn and resume at 9:30 tomorrow.
Thank you, Chair.